Anyone?
Senator McPhedran.
Thank you very much, Your Honour. Honourable colleagues, I want to acknowledge that the Parliament of Canada is on the unceded, unsurrendered territory of the Algonquin and Anishinaabe First Nations. Senator McCallum introduced Bill S-271, an act to amend the Royal Canadian Mounted Police Act, and its interconnected companion bill, S-272, an act to amend the Director of Public Prosecutions Act, some time ago. I urge all senators to review her speeches, which provide comprehensive analysis and a sound rationale for adopting this bill, which, after consulting First Nations experts, I am pleased to support. The inherent sovereignty of Indigenous peoples is recognized in the Constitution of Canada, yet most First Nations, after more than 140 years, are governed under the Indian Act, unless they have successfully negotiated viable self-government. The Indian Act establishes a limited form of local administration, but does not take into account the specific circumstances of individual communities. In contrast, self-governing First Nations can make their own laws and policies and have decision-making power in a broad range of matters. This includes matters internal to their communities and integral to their cultures and traditions. The intent of this bill and its companion, Bill S-272, is to redress a legal quandary that has arisen on the enforceability or perceived unenforceability of laws created by self-governing First Nations that do not fall under the umbrella of the Indian Act. S-271 addresses issues of policing and enforcement of First Nations law, and S-272 addresses the public prosecution of these laws. Colleagues, if any local government in this country enacted laws for the governance of their community, only to find that these laws were essentially ignored by police forces, no charges laid, no prosecutions in court, how long do you suppose that such a situation would be permitted to continue? Decades? No. Grand Chief Garrison Settee for Manitoba Kiwatwani Okimakanak Incorporated, or MKO, told a parliamentary committee in the other place, quote, First Nation bylaws have not been enforced by policing authorities or prosecuted for 25 years in Manitoba, end of quote. This bill proposes two simple yet impactful amendments to the Royal Canadian Mounted Police Act, or the RCMP Act. First, it adds the term, quote, First Nations law. It's not a new creation. It has already been defined in legislation, specifically in the Framework Agreement on First Nation Land Management Act as, quote, law that is enacted by a First Nation in accordance with the Framework Agreement and the Land Code of that First Nation, end of quote. Second, it amends the RCMP Act, enumerating duties of RCMP peace officers in Section 18, bracket A, that states, quote, it is the duty of members who are peace officers, subject to the orders of the Commissioner, to perform all duties that are assigned to peace officers in relation to the preservation of the peace, the prevention of crime, and of offences against the laws of Canada and the laws in force in any province in which they may be employed, and the apprehension of criminals and offenders and others who may be lawfully taken into custody, end of quote. The amendment to Section 18 proposed in this bill adds, quote, First Nations law, quote, to the list of federal and provincial laws that the RCMP is empowered and obliged to enforce. Thus, the amended text would read, quote, the prevention of crime and of offences against the laws of Canada and the laws in force in any province or First Nations law in which they may be employed, end of quote. Honourable colleagues, enforcement of law by First Nations on their lands is key to self-determination and self-government. Recent decades produced legislation in Canada to redress structural failings of the Indian Act, to repeal its antiquated provisions, to modernize government-Indigenous relations, to recognize and enhance First Nations autonomy and self-governance. Here are just three examples. First, the Framework Agreement on First Nation Land Management is a First Nation developed and led government-to-government agreement signed by 13 First Nations and Canada on February 12, 1996, intended to create new and enhanced lawmaking authorities to support the self-determination of First Nations, principally by replacing 44 sections of the Indian Act with First Nations laws through a community-developed and approved land code, initially as Bill C-49, the First Nations Land Management Act in 1999, which was replaced by the more comprehensive Framework Agreement on First Nation Land Management Act in 2022. The Framework Agreement expanded the range of autonomous powers that First Nations could exercise, no longer leaving them at the discretion of the Governor and Council or Minister. Once a signatory to the Framework Agreement, a First Nation is empowered to create a land code that outlines how the community will work together to develop laws and policies for governing and managing their reserve lands and resources. As of November 2024, there are 213 First Nation signatories to this Framework Agreement, of which 122 have enacted their own land codes. Second, Bill C-428, the Indian Act Amendment and Replacement Act 2014, eliminated the prerequisite for the minister's oversight in regard to the submission, coming into force, and disallowance of bylaws, which is to say, it was intended to grant to First Nations the autonomy and responsibility over the development, enactment, and coming into force of bylaws and the day-to-day governance of their communities. Unfortunately, despite the intent of Parliament to enhance the self-determining lawmaking powers of First Nations, Bill C-49 and Bill C-428 have actually created, quote, stranded regimes, quote, of First Nation laws that are not enforced by the RCMP and have not been subject to prosecution by the Public Prosecution Service of Canada. To quote from Chief Robert Louie and Chief Keith Blake of the First Nations Land Advisory Board, appearing in The Other Place, many First Nations have achieved tremendous success in governing lands under the Framework Agreement, leading a revolutionary change with advances in lawmaking, retaking control over lands and the environment, dramatic changes in finances and taxation, multi-million-dollar economic projects, and so much more. Despite this success, there is immense frustration over the difficulties we face with enforcement of First Nation laws. Self-government cannot adequately function without enforcement of laws. Freedom from the inadequate Indian Act is meaningless if First Nations laws have no traction. End of quote. Before giving my third example, I am moved to note the tributes yesterday honoring Senator Murray Sinclair, known now by his spirit name, Mazini Gazakiban, and his role in securing Bill C-15, committing Canada to implement the principles of the United Nations Declaration on the Rights of Indigenous Peoples. Articles 18, 19, 20 of this declaration commit Canada to honoring First Nations, quote, right to decision-making powers in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions, end of quote. Article 26 of the Declaration requires states to, quote, give legal recognition and protection to these lands, territories, and resources with due respect to the customs, traditions, and land tenure systems of the Indigenous peoples concerned, end of quote. Colleagues, in the course of carrying out their responsibilities, police officers are daily called upon to exercise sound judgment in how best to fulfill their mandated duties. Each situation is unique. Each requires careful judgment on how to resolve conflict. In considering whether or not to lay charges, officers use their discretion to weigh factors such as nature of offense, safety, socioeconomic factors, victims' wishes, alternate paths of de-escalation, or conflict resolution. But a different reality on the ground was described by witnesses before a parliamentary committee in The Other Place. Quote from the Tlamin Nation noted that the RCMP often decline to enforce treaty or land code laws because they are of the opinion that these are akin to municipal bylaws. This interpretation is incorrect, as these are laws, end of quote. Representatives of the Comox First Nations gave account of RCMP refusing to enforce First Nations land code trespass laws, Quote, the RCMP said they could not charge offenders under the land code as our laws are not, quote, real laws, end of quote. The Crown would not prosecute as it didn't recognize our laws or the authority we had to create these laws, end of quote. Chief Louis, speaking on behalf of the Land Advisory Board, representing more than 100 First Nations with enacted land codes, summarized the situation. And I quote, many land code First Nations have faced refusal from police forces when they ask for help, with police forces expressing concerns regarding validity of land code laws, concerns about potential liability of police officers, and uncertainty regarding who will prosecute laws even if charges are laid. It has been difficult to this point to reach agreement with either federal or provincial prosecutors to tackle First Nation laws under the Framework Agreement, end of quote. Some RCMP representatives reinforced his points in testimony to the Parliamentary Committee in the other place. RCMP Inspector Jeff Preston noted, and I quote, after 2014, we weren't able to enforce the bylaws anymore, and that caused an immediate friction with all of the community and the police who were seen as the ones who suddenly stopped. It was perceived as our decision. My message to the First Nations was that the RCMP is standing with you. We support you. We want this to happen. We just can't enforce it until there's prosecution, end of quote. Such evidence is reinforced by research and advocacy of Indigenous law experts and academics. To quote Indigenous law expert Nick Sousan, from the perspective of a police force, when facing a request to enforce a forced removal from a reserve, the police chief or detachment commander must consider whether to allocate the time and resources to a law that has no chance of implementation because there is no provincial territorial court that recognizes it. Many police forces view Indian Act bylaws as not having the same legitimacy as federal, provincial, territorial, and municipal law, and as not being worth the liability risk and resource expense required to enforce them, end of quote. Enforcement and prosecution of federal laws falls under the remit of the Public Prosecution Service of Canada, the PPSC, a national independent prosecuting authority for federal offences, providing legal advice to law enforcement officials. PPSC officials advise the House Committee that PPSC only prosecutes bylaws that have been officially reviewed, but there is no mandatory departmental review of First Nations land code laws. So guess what doesn't get reviewed? Chief Keith Blake adroitly summed up this catch-22. Quote, most jurisdictions across the country do not recognize or prosecute nation-legislated offences. The challenge most Indigenous communities face in this country is the refusal or the reluctance to have provincial Crown prosecutors or federal prosecutors undertake the prosecution of these nation legislation cases, end of quote. Colleagues, law enforcement and prosecution are two separate entities, yet directly impact upon one another and must routinely rely on each other to carry out their objectives in an interdependent relationship. But this model has failed First Nations. Historically, for generations, resulted in the stranded regimes of First Nations laws. Simply put, it's a big mess. The causes of this legislative and bureaucratic mess are known. Solutions are available. What is lacking is political leadership, and this is why Bills 271 and 272 are before you now. The Indian Act itself does not specify whether the provinces, territories, federal government, or First Nations themselves are responsible for prosecuting bylaw infractions. Lack of federal and provincial territorial coordinated leadership on this issue has led to a situation where often no federal, provincial, territorial government chooses to respect First Nation laws. Colleagues, this is a complex issue. The challenges and obstacles to a clear solution require scrutiny, exactly what Senate committees do well. I commend Senator McCallum for supporting the First Nations across the country who are struggling to protect their communities. Please help move Bill S-271 forward for further study. Thank you. Merci. Miigwech.
Senator Boniface, you have a quick question?
Yes, would you take a question, Senator McPhedran?
Yes.
Thank you very much. Were you aware, and perhaps I'm suggesting this to be included for this study, that in Ontario, because you're a different jurisdiction there, you don't have the RCMP in that role, that in fact the First Nations and Nishnabek Nation have actually worked out a solution for this, and they're prosecuted successfully in court in Sault Ste. Marie. And would you agree with me? This would be a good model to look at because it's actually a creation that they have designed themselves.
Senator McPhedran.
Thank you very much for the question and the information, Senator Boniface. I would agree, and in my next speech, I will reference a similar operation in Manitoba. Thank you.